In today's video, we discuss some exceptions to Stark Law. Stark Law deals with improper referrals by physicians and certain other healthcare practitioners. If you've watched some of our other videos, you know that we cover a couple of these topics like physician services and in-office ancillary services. Many of our clients have asked us whether there are other categories of exceptions to Stark Law and what they are. I'm Michael H. Cohen, founding attorney of the Cohen Healthcare Law Group. We've advised over 1,000 healthcare clients on similar healthcare and FDA legal issues. Today I'm going to cover some more exceptions to Stark Law, which again governs referrals by physicians and certain other healthcare practitioners. By the time we get through, you'll know more about some of the categories of exceptions to Stark that might apply to your healthcare operation. The first category is services furnished by an organization to its enrollees. Physicians can make referrals to organizations that provide a prepaid health service. Examples of prepaid health plans are approved HMOs, approved CMPs, plans approved by the Centers for Medicare and Medicaid Services, as well as other plans identified in Stark Law. This exception category applies to organizations and entities that contract with the organization. Another category is for academic medical centers. Physicians who have a financial relationship with an academic medical center can make referrals to that center, typically without running afoul of Stark Law, if certain conditions are met. The physicians must be bona fide employees of the medical center, have a valid state license in the state in which the center is located, be members of the facility's faculty, and provide clinical teaching services at the center for which they are compensated. In addition, the center must meet other criteria for approval that are detailed in Stark Law. If all of the above conditions are met, the exception will apply. A third exception category exists for implants furnished by an ambulatory surgery center. The acceptable implants currently include cochlear implants, intraocular implants, prosthetic device implants, and others. The implant procedure must be done at the ambulatory surgery center by the referring physician or one who belongs to the referring physician's medical group. As you can tell, each of these exceptions have detailed requirements and conditions that we can't address in the span of a video, but an experienced healthcare lawyer can give you the full picture on these as well as entirely other exception categories that we didn't touch on today. Thanks for watching. If you still have questions, click on the link below, cohenhealthcarelaw.com/contact, to send us a message or book an appointment. We know that Stark Law is very deep and that the exceptions are very nested, and that there are exceptions within the exceptions within the exceptions. As well, typically where you have a Stark violation, you also have to contend with the anti-kickback law. Further, even if you don't have federal Stark applying or the federal anti-kickback statute, more than likely you'll have applicable state law which contains mirrors to the Stark self-referral law on the federal side and the federal anti-kickback statute. We look forward to your connecting with us, and we look forward to speaking with you soon.